Good morning, everyone. Welcome. Let's call to order this hearing of the Assessment Appeals Board for June 8th, 2015. And we'll start by asking our clerk to call roll.
Board Member Crow.
Present.
Board Member Curtis.
Present.
Board Member Stern.
Present. Thank you. Okay, now I'd like to ask everyone to stand for the Pledge of Allegiance. If you intend to provide testimony today, please remain standing, and then we'll get you sworn in. Ready, begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, and if you do intend to provide testimony today, please remain standing.
So everyone that's addressing the board this morning is standing. I'll now place you under oath. When I complete reading your oath, state I do. Please raise your right arm. You and each of you do solemnly affirm that the testimony you're about to give and the matters now pending before this board will be the truth, the whole truth, and nothing but the truth. Thank you. You may now be seated.
Great. Okay. Thanks, everyone, for being here. We'll first go through our agenda to determine what items will continue today and the status of each. And first, we'll ask our clerk to go through the agenda review.
We have a fairly short agenda review this morning. Item number 5, agenda review. The clerk of the board recommends approval of the agenda review by the Assessment Appeals Board. The agenda review consists of the following agenda items. Item number 52, application number 14-10249, applicant Power One Incorporated and Alan Wells, removed from agenda due to the submission of a withdrawal. Item number 69, application number 14-11191. Applicant Realty Associates Fund 8 LP, continued to July 13th, 2015, pending receipt of original stipulation. Item number 70 through 72, application number 14-11218, 14-11219, and 14-11226, applicant KB Home, removed from the agenda due to submission of a withdrawal. Item number 74 through 75, application number 14-11309 and 14-11310, applicant TBYCI LLC as leasee, removed from agenda due to submission of a withdrawal. That completes the agenda review.
Okay. Any comments or questions from the board? Okay. So I'm looking for a motion to approve the agenda review.
So moved. I'll second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and motion carries. So we do have several other items on the agenda. We'll go through each one and determine the status, and those who will be hearing today will come back to those items. So we'll start with items 6 through 28. Applicant is NetJets Aviation.
Yes, this is a multiple years of stipulations which were submitted to the board via email on Thursday, and they represent appeals back from 2008 all the way through 2012.
Okay, and did everyone get a chance to review those emailed stipulations? Okay.
Yes.
If there aren't any questions or comments, then we'll look for a motion to approve.
So moved. I'll second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and motion carries. Next, item 29, application 12-12169. Applicant is Bank of America NT and SA. Looks like we're continued from January 12th.
Good morning. Kenton Schubel, Ryan LLC for the applicant.
Welcome back, Mr. Schubel.
Thank you.
Are you prepared to move forward today?
No, we're not, Mr. Stern. The application in question resulted in some activity on the assessor's part that then resulted in further applications filed. We're currently waiting for the assessor's activities to finalize, to post, to refunds issue, and the applications filed on the assessor's action are calendared on August 3rd. We'd like to request the board to continue these and reschedule them on the same day. They can be addressed at that time.
Okay, and any comments from the assessor?
Yeah, the assessor is in agreement that we should continue this to August 3rd.
Okay.
The clerk would just ask for clarification. This has already been continued 4 times, so will the parties be prepared to move forward on August 3rd with valuation matters?
We actually believe we can get a resolution before that time.
Okay.
Okay, and Mr. Schubel, August 3rd, acceptable date?
Yes, it is. Thank you.
Okay, any questions, comments from the board? Okay, looking for a motion to continue to August 3rd.
So moved. I'll second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and motion carries.
And then, Brendan, there's one related application.
Sure,
It
which number is that?
It is item 77.
Okay, thank you. So let's skip forward to item 77, application 14-11-312, and the applicant is GPT GIG BOA Portfolio LLC.
And it's the same property, it's the same set of facts, and this is just the protective 2014 Prop 8.
Okay.
So if we could do the same.
August 3rd
Yes,
continuance
please.
request? Okay. And any comments from the assessor?
No further comments from the assessor.
Okay. August 3rd
would be
again,
fine.
okay, with continuance?
Yes.
Great. Okay. Any questions from the board? Okay, looking for a motion to continue to August 3rd.
So moved.
Second.
Okay, moved by Mr. Crow and seconded by Mr. Curtis. Motion carries.
Thank you.
Thanks, Mr. Schubel. We'll go next to items 30 through 32, applications 12-12749 through 12-12751. Applicant is Lansco Properties, Inc.
Morning, Mr. Chairman, members of the board.
Morning.
We have 30 through 32, and there are other applications on this agenda, 46 through 47, and 67. All the same property, all the same issue that I'm going to discuss right now. We've been
Okay.
in contact with Mr. Horn and Mr.
Could you
Myers.
just state your name for the record for us?
Oh, I'm sorry.
That's
Robert
okay.
Slavin, attorney for the applicant.
Thanks, Mr. Slavin. Welcome back.
Thank you.
Go ahead.
I'm sorry. Anyway, this is a ownership issue at this stage that needs to be broached before the valuation is resolved. We have a title issue for 2009 and a BOE filing that we're waiting for the BOE to make a determination regarding a change of ownership. We've worked with the assessor's office on this matter. We believe that when the ownership issues resolve themselves, it's very possible that the valuation issues may be resolved as well too. So we're waiting for the BOE, and we're also waiting for Superior Court. So we're not back here again anytime soon to allow this to really season and resolve itself. I'd like to see if we could have a continuance to December, willing to sign waivers to the statute of limitations.
Okay, thank you. Any comments from the assessor?
Good morning, board members, council. Christopher Horn for the assessor's office. Mr. Slavin and the applicant have been very forthcoming with information regarding not only the transfer but also other valuation issues. The assessor's office is hoping that when the transfers for 2009 are processed, that the valuation issues can be taken into consideration at that time, and there'll be no need for future appeals. Right now, we expect these appeals that are hanging out there to eventually be withdrawn because they're going to become void because of the transfer. Right now, these appeals are staying active merely for a protective status. We have no problem pushing this off until December, if that's okay with the clerk of the board, because it will allow the time for the state to render a decision and also Superior Court.
Okay. And Mr. Horn, are you, let's see, items 46 and 47 and 67 looks like same applicant, similar issues?
Absolutely, same property,
Okay.
same issues.
And these are actually Prop 8 applications. The base value still needs to be resolved, actually even before these Prop 8s are resolved.
Okay. Mr. Vlahakis, is there a December date that you might recommend?
Not at this time. We can continue to November 3rd, which is just a month sooner, but I don't have any confirmed December dates at this time.
Are there any January confirmed dates?
No, the latest I'm authorized to schedule hearings for is November 3rd.
Okay. Hold on one moment. Okay. Well, until determine a different date, is November 3rd okay?
Yeah.
Go to the applicant first.
November 3rd is fine. What I'd like to request the board, though, is if, depending upon how things go through the course of the summer and fall with this litigation, should we need to push this into December or January, I would like to see if I could get authorization from the board to deal directly with the clerk as far as a new date as opposed to making another appearance.
Okay, I'm not sure if we're able to do that or not. We'll go to our legal counsel.
The applicant has made his record in requesting the December date. The clerk has indicated that the latest date possible is November. We can't bind a future board's hands. I don't know who's going to be on when you come forward and request. So this board can only act today, but we've heard the position of the applicant and of the assessor's office that it's in the interest of all for the BOE and the court to clarify. So without binding any future board, I can't see anything. I can't anticipate any problems, but we can't bind a future board.
Okay.
Okay.
Okay, thank you. November 3rd okay with the assessor?
November 3rd is acceptable, thank you.
Okay, and to our clerk, is it okay to make a motion for all three of these items at the same time? Or-
Yeah, I've combined so that we're addressing all of them. It's just not showing on the public. But
Okay.
yeah, this motion will address all three blocks of cases.
Any questions or comments from the board? Okay, so I think we're looking for a motion to continue items 30 through 32, 46, 47, and 67 to November 3rd.
So moved. I'll second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and motion carries.
Thank you very much.
Okay,
Thank you.
thank you. Next, item 33, application 13-11029, and the applicant is Kathleen Brassfield.
Yes, the board approved a stipulation for this item on October 6, 2014. Apparently there were some issues with that stipulation. It was not correct as to what the applicant had appealed. So a revised stipulation has been executed that properly addresses the applicant's base year value, which the original stipulation did not. That was provided to the board this morning. Should be a part of your packets. I did not email it to you last week as I did not have it completely ready to go until late Friday. So the request would be to vacate the stipulation approved on October 6, 2014, and then to, which is due to a ministerial error, and then approve the corrected stipulation.
Okay, thank you. I think we all have a copy of the memo and the stipulation. Are there any questions, comments from the board? Okay, so we're looking for a motion to, I want to make sure we're using the correct language, to approve the corrected stipulation.
Well, yeah, first we need the board to vacate the stipulation they originally approved. I apologize.
Okay. So then we're looking for a motion to
So
vacate.
moved.
Second.
Moved by Mr. Crow, seconded by Mr. Curtis. And motion carries. And then next, the motion to approve the corrected stipulation.
So moved.
Second again.
Okay, again moved by Mr. Crow, seconded by Mr. Curtis.
All right, and that's all we needed for that item.
Okay, thank you. Next, items 34 through 37, applications 13, 11, 535 through 538, and applicant is Target Corporation.
Good morning, Mr. Chairman, board members. Kelly Irwin here to represent the taxpayer.
Morning.
Good morning. It's actually the same for applications, agenda items 38 through 41.
Okay.
We are working with the assessor's office, but we just need additional time. So we're here to request a continuance.
Okay, thank you. Any comments from the assessor?
And I forgot to give you my name also. I'm Kent Meyer, Ventura County Assessor's Office.
Morning, Mr. Meyer.
Good morning. The applicant has provided us the information that we're requesting and is still taking time to analyze all the information, so we would like a continuance.
Okay, any range of dates that works for the...
We believe we can come to a resolution. I'd like to suggest November 3rd.
Okay, and Ms. Irwin, is November 3rd okay with the applicant?
That's fine. Thank you.
Okay, any questions from the board? Okay, looking for a motion to continue to November 3rd, and this would be for items 34 through 37 and 38 through 41. I want to make sure that's okay with the assessor and with the applicant.
The assessor agrees.
Okay.
Applicant agrees.
So moved.
I'll second that motion.
Okay, moved by Mr. Curtis and seconded by Mr. Crow, and motion carries. Thanks.
Thank you.
And next, items 42 through 45, applications 13, 11-845 through 13, 11-848. Applicant is Kohl's Department Stores, Inc.
Kelly Irwin here to represent the taxpayer. We are working with the same assessor and just need additional time requesting a continuance.
Okay, November 3rd, again?
That would
okay.
be fantastic.
Okay, and Mr. Meyer?
No further comments. It's same issue as the previous applicant.
All right. Any questions from the board?
Just for the record, the clerk would note this one is close to the expiration of the 2-year period expiring. The agent has executed and submitted a waiver to extend time for hearing, so a continuance can be allowed today.
Okay, thanks, Mr. Vlahakis. Okay, looking for a motion to continue to November 3rd.
So moved.
And second.
Okay, moved by Mr. Crow, seconded by Mr. Curtis. Motion carries.
Thank
Next, thank you. Next, items 48 and 49, applications 13-12311 and 14-10348. Applicant is Connie Steps.
That's correct.
Good morning.
Good morning. I'm Connie Steps. So I did speak to Mr. Myers, and I was actually going to try to postpone it, but I got a whopping bill over the weekend for $14,000, and it was supposed to be resolved before this hearing because we had already asked for a continuance. So when I spoke to Mr. Myers this morning, I would like to request another continuance to resolve that.
Okay.
And they're both kind of tied in together.
Okay.
So as soon as I leave here, I'm going to go over to the tax preparer's office.
Okay. Thank you. Any comments from the assessor?
Yeah, the assessor has already initiated a roll correction on this property. It was processed in February. It has not been completed by the auditor's office. Because of the timing, the auditor will not be able to get to this correction until November. So we'd like to continue this to November.
Okay. And is November 3rd?
Yeah, I think that's the only one scheduled for that month.
Okay. And Ms. Steps, is November 3rd okay for a
Yes.
continuance date?
Yes.
Okay. Any questions from or comments from the board? Okay, so looking for a motion to continue to November 3rd.
So moved.
I'll second that motion.
Okay, moved by Mr.
Thank
Curtis,
you.
seconded by Mr. Crow. Thank you. See you
Okay,
then.
have a good day.
You too.
And just one question.
Go ahead.
Brendan, Mr. Vlahakis, the 2013 appeal, when was that one filed?
The 2 years doesn't expire until May 4th of 2006, or sorry, April 4th of 2016. So that would mean it was filed April 6th of 2014. So no waivers required at this
Okay.
time.
Thank you.
Okay, thank you. Thank you. Next, item 50, application 14-10100. Applicant is J. Harris Industrial Water Treatment.
Good morning.
Morning.
Ben DeSantis representing J. Harris Industrial Water.
Did you say DeSantis?
Correct.
Great. And Mr. DeSantis, are you ready to move forward today?
No, we would like to request a continuance.
Okay. Any comments from the assessor?
Kent Meyer, Ventura County Assessor's Office. We have not received all the information requested. Specifically, we are looking for a declaration of compliance and an insurance policy. So if we continue this, we would like to request that all the information be provided no less than 30 days prior to the hearing.
Okay. And back to Mr. DeSantis, the information mentioned by the assessor, is that something that the applicant will be able to produce?
That will not be a problem.
Okay. Is there a range of dates either for the applicant or assessor that seem workable?
We're looking at November 3rd again.
Okay, and is November 3rd okay with you?
That's fine.
Okay. Any questions or comments from the board? Okay, so it looks like we're looking for a motion to continue to November 3rd with the stipulation that the applicant provide requested information 30 days or more in advance.
So moved.
Second?
Okay, moved by Mr. Crowe, seconded by Mr. Curtis, and motion carries. So we'll see you then.
Thank you very much.
Okay. Next, item 51, application 14-10218. Applicant is Ricardo Garcidueñas.
That's correct. Good morning.
Good morning.
Chairman, good morning, members. I'm here to justify why I was not here for my hearing. On January 27, 2015, Mr. Rick Denham informed me that I don't have to be at this hearing on that day because we have mutually agreed to the new assessed value of my property. At that point, so since he says he's going to take over, I leave it all settled, and time went by. On 3/23/15, I received a notice of denial from this board, I believe, that my stipulation was denied. I called Mr. Rick Denham right away, and I says, why was that? And he stated that he emailed a document to me, which I never received, and also I stated to him, I says, why you didn't put this in the mail, in a regular U.S. mail? He says, we don't do that when the taxpayer provides an email. I says, okay, what do we do from now? I says, that's not right. He says, well, you can appeal, and this is why I'm here.
Okay.
The stipulation was agreed, Mr. Chairman, there's a copy there, and I never received it, I cannot sign it. So I asked the board to reconsider and approve my stipulation since it's already done.
Okay, thank you. And good morning, Mr. Denham. Before we go to you, let's just a little recap for the board so we know what we're looking at. This is a request for reconsideration of a hearing officer decision, and we have the application in front of us. Before we go to Mr. Denham, are there any questions from the board for the applicant? Okay.
Thank you. Rick Denham, Ventura County Assessor's Office, and hopefully I can maybe clarify anything that you might have. According to our electronic record, we indeed sent a timely stipulation. The Assessor's Office, believe it or not, often sends stipulations that are eventually never signed. I know that sounds confusing to all the passion that you see in this room, but that does occur. And in this case, we did not receive back any stipulation prior to the hearing, and it was dismissed due to lack of appearance, which we believe is correct. The Assessor's Office, normally is very touchy about opening up hearings, but if this was opened up in order for this applicant to just sign the stipulation, the Assessor's Office has no objection in this particular case for just opening up to sign the stipulation. I have a copy of it here, and that we indeed sent this taxpayer a stipulation. So I want to make that very clear.
Okay, so it sounds like, Mr. Denham, what you're saying is that the assessor will accept the stipulation if it's executed today?
If the board were to open this up just for and specifically it was for $570,000. And if that was opened up this day, the assessor's office has no objection for just that specific item, because this looks like maybe more clerical in nature than it appears that way to us anyway.
Okay. And Mr. Garza-Duenas, is that agreeable to you?
Yes.
Okay. Are there any questions from the board or?
So to the assessor, when you said you sent it to him via email
Correct.
to have it signed,
Yes.
would it be electronically signed on the email?
Well, they have
Like
a choice at the other end. We request that they send it back electronically and also through the mail.
So they could sign it electronically,
Correct.
like by checking a box or something?
No, that is not correct. They can only sign it, they would have to print it out and physically sign it and mail it back.
Correct.
Oh, okay. Not
Well, actually,
like-
some guys, I guess, have the ability to sign electronically within their system, but what we normally do, our standard operating procedure is we ask immediately for if they have the ability to send a scanned copy back to us. We then receive that as a preliminary step and obviously turn it into the board. We did not receive that, and then some people skip that step and they just either bring it in or mail it with the original, because as you know, in most cases you need the original copy in order for the refund or the minute order to go forward, and we then wait for it. And sometimes it's kind of last minute, so they'll send it in on a Thursday, and then we'll bring it to the hearing on Monday, just the electronic copy.
Sure.
And then later on, it's approved as a stip when we get the final. Unfortunately, neither of those things occurred this time. We didn't get it back, and like I say, in fairness to the assessor's office, we have this baffling phenomenon that some people get our stips, never sign them, never come in, never talk to us again. And so we're not always aware of what people's thoughts are. I know I was baffled when that first happened, but it's actually happened several times over the course of my career, and I have no explanation for it.
Okay. Thank you. Mr. Crow, do you have any? Just a quick question for our clerk. Does it, opening the hearing for the purpose of signing stipulation, or for our legal counsel, is there any reason why we shouldn't do that?
If the board found good cause due to the failure to receive the email that was sent and failure to attend the hearing, that it wasn't on purpose that the applicant failed to appear, but due to the communication difficulties between the parties, the board could find good cause to reopen the hearing. If I understand correctly, both the applicant and Mr. Denham have indicated the parties are willing to stipulate to a bottom line number of $570,000. If that's the party's current willingness, the board can accept such a stipulation.
Thank you. So unless there are any concerns, we'll go ahead and do that. Open the hearing right now, and the stipulation can be executed, and then we'll move on. Is that?
So the action the board would need to take at this time is to vacate the hearing officer's decision to deny due to lack of appearance on March 10th, 2015.
Doesn't matter if I was the hearing officer.
The clerk would recommend that your opinion would be the most valuable because you are the hearing officer and the one who denied it. So.
Wow.
Okay.
More important than we are.
Wow. Okay.
Okay, so then do we have a motion then to vacate the hearing officer's decision on this item?
So moved.
I'll second that.
Okay, moved by Mr. Crowe, seconded by Mr. Curtis, and that motion carries. And so then I believe that allows us to then proceed and...
Right. The applicant submitted an original stipulation with their request, which I forwarded to the assessor's office. I'm not sure if they have that.
I'll just have him sign another one right now with this date, because technically it has to be opened as of today.
Okay, so did you have one?
I happen to have one.
Okay.
If you have that and a
I
pen,
didn't want to
then we'll move
anticipate
forward.
your ruling, gentlemen, but I just happen to have one.
Great, let's do that.
Okay, can you sign and date that today, and make sure you print the bottom. Thank you.
To the assessor's office, I don't want to hijack the topic here, but have you ever thought about having a ability for the people just to sign it electronically, like a DocuSign?
That's actually a board rule that it has to have an original signature.
Okay.
We're actually looking into changing the board rules. The rule's like over 20 years old, but the current rule is they have to submit an original for the board. So when we get around to revised board rules, that'll be taken into consideration that an original might not be necessary.
Also, to kind of follow up on that, our current system tells us whether that email accepted our item. And in our, now I have to rely on electronic confirmation, but it did say that it reached the email that was on the application.
Sure,
And
but it might have gone into his spam folder or something like
once
that.
again,
Sure.
and some, we realize that, and some, we've had to send them twice, and people have, like I said, there's various levels of communication depending on the time of, sometimes it's last minute, sometimes there's a, little bit of time in between, and
Gotcha.
but that's how we did it, but we do realize this happens. This isn't the first situation, but I guess everyone's different.
Okay.
Thank you.
Thank
And
you.
I'm going to make a copy of this and then submit it if that's okay.
Okay.
I just want to have a copy for the taxpayer and a copy for us because it's today's date.
Yeah, we'll be mailing a copy this week, but
Okay.
'cause I think the board wants to approve it right now. So if
Oh,
could,
we should do that, and then you can
Can you
make copies.
give it to Kent for sure? The same stipulation is attached to the application you currently have. So if you want to review that while it's going through the signature process, it should be near the back. It's attached to the applicant's request for reconsideration, which is attached to the application I gave you.
Got it.
Okay, so looking for motion to approve the stipulation.
So moved.
Second.
Okay, moved by Mr. Crow, seconded by Ms. Curtis, and motion carries. And Mr. Vlahakis, I'll put the original right up here. Thank you.
Okay, so that item is complete and closed now.
Thank you. Okay, next item. 53. Application 14-10267. Applicant is Howe Industries.
Good morning.
Morning.
Mark Howe. I'm here to request another continuance. I spoke with the assessor, Arnold Greenberg, a couple weeks ago, who believes we can come to a settlement on this, which I'm willing to do. He asked for a piece of supporting documentation, which I provided him. Unfortunately, I think he went on vacation. So that's why I'm in here asking for a continuance, and we should be able to resolve this as soon as he gets back.
Thank you. Any comments from the assessor?
The assessor would like to have this continued to August 3rd.
Okay, and Mr. Howe, is August 3rd okay?
Good. That's good.
Okay, any questions, comments from the board? Okay, looking for a motion to continue to August 3rd.
So moved.
I'll second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow. Motion carries. Thanks.
Okay. Thank you.
Next, item 54, application 14-10347. Applicant is Ashley Construction, Inc.
Good morning, Mr. Chairman,
Morning.
board, staff. I am Mike Ashley, president of Ashley Construction. We requested a review of the assessment on airplane tail number N285 Gulf Charlie when we received the assessor's bill for this year. There were basically 4 parts that were in dispute during the negotiations on this matter, of which I believe 3 of them have been resolved and stipulated by the assessor's office. The first one was the value of the airplane itself. The second was a contention that we had not filed and paid our assessment on time. The third was the corrected value of the plane. And the fourth, which is still being discussed, is the tax additional amount that the assessor's office wished to assess on the airplane. When the plane was originally assessed, it was considerably more than this plane would have been purchased for in the beginning. Again, that was discussed and that has been reduced. The second matter, which was the filing of the application for the review and paying our bill in the assessor's office and checking, they determined that that was their mistake. It had been filed and paid on time, so that was no longer on the table. The last was the present value of the airplane, which I believe we are in agreement on the value of the plane at this time. The last item that we are here to appeal is the assessor's office indication to us at our last discussion that they were adding on approximately $240,000 in value.
Mr. Ashley, let me just interrupt you for 1 second.
Sure.
Are you prepared today to move forward with the hearing?
Yes.
Okay. I just
Yes.
want to understand our status. And next, let's just go to the assessor with any comments on the status of the application.
Yes. As Mr. Ashley was saying, there's multiple levels on this specific appeal. If we are in agreement that the plane is worth $3,050,000, we are prepared to move forward. If we're not in agreement on the $3,050,000 on the valuation of the plane, we need a continuance.
I am prepared to agree with the $3,050,000.
Okay.
We can move forward.
And so just for clarification from the assessor, we would be moving forward with, if the valuation is agreed, what would the outstanding issues be?
The outstanding issue is sales tax. For personal property, we are legally obligated to include sales price. So that's the contention that we're having right now.
Okay. Okay, great. So here's what we'll do. We're going to go forward with the hearing, but first we'd like to go through the rest of our agenda items. We'll come back and hear your item first.
All right.
And it shouldn't be too long.
Good. Thank you
Okay.
very much.
Thank you. Okay. Next, let's go to item 55, application 14-10619. Applicant is Treasure Franchise Company, LLC.
No one has checked in for this item this morning. The clerk of the board would recommend denial due to lack of appearance.
Okay, so just to make sure we don't have any representatives of Treasure Franchise Company, LLC. Looks like we don't. And so looking for a motion to deny due to lack of appearance, unless there are any other questions from the board.
So moved.
Second?
Okay, moved by Mr. Curtis, moved by Mr. Crow, seconded by Mr. Curtis, and motion carries. Next, item 56, application 14-10620. Wait, is that right? Yes. 14-10620. Applicant is Tesoro Refining and Marketing Company.
Yes, no one has checked in for this item this morning. The clerk of the board would recommend denial due to lack of appearance.
And no one here for Tesoro. Okay. Any questions from the board? No. Looking for a motion to deny due to lack of appearance. And it looks like we also have same applicant, items 57 through 62. Tesoro South Coast Company.
So moved?
I'll second that motion.
Okay. And so, Mr. Vlahakis, I think what we just did was denied 56 through 62. Is that right, Mr. Curtis? In terms of motion?
56 and 57 through 62.
Right. Okay.
Two motions.
Okay, next, items 63 and 64. Application numbers 14-10804 and 14-11487. Applicant is Jae Sun Kim.
County Council will need the board to continue the due date on the findings to June 22nd.
Okay. Any questions from the board? Okay, looking for a motion to continue the deadline for the findings of fact for these items to June 22nd.
So moved.
I'll second that motion.
Okay. Moved by Mr. Curtis, seconded by Mr. Crow. Motion carries. Next, item 65, application 14-10840. Applicant is Shahram. I'll spell last name Shahrukkhfar.
No one has checked in for this item this morning. The clerk of the board would recommend denial due to lack of appearance.
Okay. Anyone representing item 65? No. So we will, unless there are any questions from the board, look for a motion to deny due to lack of appearance.
So moved.
And second.
Okay, moved by Mr. Curtis, seconded by Mr. Curtis. Crow?
Crow, Curtis.
Moved by Mr. Crow, seconded by Mr. Curtis. I wasn't sure if anyone was listening to me anyway, so might as well.
Committee C.
Right. Okay. Next, item 66. Application 14-10841. Applicant is Andres Cardona.
This was a request for reconsideration of the hearing officer's decision on May 5th, 2015. The applicant came into our office the day after the hearing and informed us, he spoke Spanish, so he spoke with our bilingual staff and submitted his request for reconsideration in Spanish, but our bilingual staff verified it. There was a death in his family on the day of the hearing, so that would have qualified as good cause, but we told him he would have to still come into the board this morning and request the reconsideration. He has not checked in or came in this morning, so not sure what he was, he did indicate he'd be going in for surgery at the end of June, which is why we expedited his hearing today. I'm not sure if medical issues are the reasons he's not here today. So again, it's up to the board. He clearly met the good cause because there's a death on the day of the hearing, but he isn't here today. So it's at the board's discretion if they want to reopen this and continue it or not.
Okay. And
so if we reopen it, we would have to ask for a continuation then, I guess. Is that
Right.
correct, since he's not here.
It was a hearing officer, and the next hearing we have is October 6th for hearing officer, and we informed him that if he came today and reopened it, that we'd reschedule it for October 6th. So that he was aware of all the dates that were going to be set up. I'm not sure why he's not here today.
so I guess that was my next question. There's no indication of why he's not here.
There's no indication. I know when he came in, he indicated he was going to be in surgery on June 22nd, which is why we didn't schedule his reconsideration for that point. I'm not sure if that's why he's not here today. We haven't got any communication as to why he's not present today.
If we deny the request for reconsideration today because of lack of appearance, can that be appealed if he does want to come back?
I believe you can't ask for reconsideration of a reconsideration.
Any questions, comments from the board? I think we usually require the applicant to be here in order to agree to a continuance. Is that right?
I think I'm only aware of one instance where there was maybe some out-of-state people caring for an elderly person in the past year where there might have been a variation from normal policy.
Right. I'm not sure if the requirement for appearance, I think, only pertains to hearings on valuation. I don't know. That's up to the interpretation of council and the board. I'm not making too strong of a recommendation one way or the other, just because if we would have known about the death on the day of the hearing, prior to the denial, we would have recommended the board reschedule it, but it's complicated. There's lots of issues on this one, so I'm not sure. I don't want to make too strong of a suggestion either way for the board.
And it's council's view this would be a policy call on the board's part of whether or not to accept the faxes relayed by the clerk, secondhand, in terms of acting on the motion without the presence of the person here.
I suppose we could continue it, and if he doesn't show in
October.
October, or deny it. Sorry, Mr. Crow, go ahead. You were going to say something.
Either way, that or we can make a motion to grant the continuation because of health issues.
That's fine.
Okay, so looking for a motion. The date that was, sorry, Mr. Vlahakis, go ahead.
I was going to, what we would need is a motion to vacate the hearing officer's decision to deny due to lack of appearance on May 5th, 2015.
So moved.
Second.
Okay, moved by Mr. Crow, seconded by Mr. Curtis. Motion carries. And then, along with that, the date was October 6th, if there's a motion to continue to that date.
So moved.
And second.
Okay, moved again by Mr. Crow, seconded by Mr. Curtis. Motion carries. Okay, next item 68. Mr. Vlahakis, am I going a little too
I'm
fast?
almost caught up.
Okay, sorry.
There, I'm all caught up now.
Okay, item 68, application 14-11190. Applicant is Brinker Restaurant Corp.
No one has checked in for this item this morning. The clerk of the board would recommend denial due to lack of appearance.
Okay. I'm sorry, with our last two denials, I didn't ask if there are any comments from the assessor. I assume that there were not, but I'll ask on this one.
No comments from the assessor.
Okay. Any questions from the board? Okay, so looking for a motion to deny due to lack of appearance.
So moved.
Second motion.
Got it.
Moved by Mr. Curtis, seconded by Mr. Crow. Motion carries. Next, item 73, application 14-11296. Applicant is John and Janet Czar Trust.
Hi, I'm Jeff Counter, Ryan LLC, agent for the applicant.
Morning.
We are just requesting our one-time postponement for this. Unfortunately, the confirmation card, we failed to turn that in. I apologize, it slipped through the cracks. I have been speaking with Scott Combs, the appraiser for this property. We've exchanged information. He wants additional information. So I would like a postponement so we can get the additional information and possibly work this out with the appraiser.
Okay. Any comments from the assessor?
The assessor just wants to make sure that we get the additional information no later than 30 days prior to the continued hearing.
Okay.
That should not be a problem.
Okay. Any questions from the board? Okay. Are there range of dates that are acceptable to either? Start with the assessor.
Mr. Vlahakis, how busy is August 3rd right now?
We got a lot scheduled, but I'm not sure if many people have no one's really confirmed appearance. Let's see if I have the agenda.
So I think we might have to go with November 3rd on this.
Sorry, let me review the agenda real quick. I can try to give you a quick answer. We have a lot of continued cases. It doesn't look like too busy a day, but we do have quite a few continued cases, so it's up to you and what your workload can handle. But our dates are August 2nd or November 3rd. No, sorry, August 3rd or November 2nd are available dates.
November 2nd.
It's November 2nd?
Because we've been continuing everything to November 3rd this morning.
Screw that up.
How's November 2nd or 3rd? Whichever is a Monday. Well, Mr. Vlahakis is checking.
It is November 2nd when I issue the minute orders. I'll ensure to clarify that with the applicants that I may have misguided the board on.
Okay, so it sounds like November 2nd is the date. If there aren't any questions or comments from the board, then we'll look for a motion to continue.
So moved.
And second.
Okay, moved by Mr. Crow, and seconded by Mr. Curtis.
Sir, I just wanted to clarify, was the board also requesting that the data be provided 30 days prior as part of that motion?
That was requested by the assessor, and Mr. Curtis, did you make the motion, or was it Mr. Crow?
Mr. Crow.
I did,
Sure.
yeah.
So that's up to you, Mr. Crow.
Continue. Rick, the applicant will provide the information the assessor is requesting 30 days prior to the hearing.
Yes.
Okay.
And I'll second that.
Okay,
Thank
great.
you very much.
Thank you.
Does the clerk need any motion from the board to clean up the little ministerial issue of the date being November 2nd when the board is scheduled to meet rather than November 3rd on all the previous?
If the board wants to, yeah, I mean, it's up to the board. There is no hearing on November 3rd, so.
Okay. Can we have one motion to correct all the prior motions?
Yes.
Okay, so then,
Here, I'll go ahead and, let's see, I'll read you everything. And so the clerk would request that the board correct the continued hearing dates for several cases. They are item numbers 30 through 32, application number 12, 12749 through 12, 12751. Item number 34 through 37, application number 13, 11535 through 13, 11538, applicant Target Corporation. Item number 38 through 41, application number 13, 11539 through 13, 11542, applicant Target Corporation. Item numbers 42 through 45, application number 13, 11845 through 13, 11848, applicant Kohl's Department Stores Incorporated. Item number 46 through 47, application number 13, 11949 and 13, 11950, applicant Landsco Properties. Item number 48 and 49, application number 13, 12311 and 14, 10348, applicant Connie Steeps. Item number 50, application number 14, 10100, applicant J. Harris Industrial Water Treatment. Item number 67, application number 14, 11112, applicant Landsco Properties Incorporated. And that is all. And so the clerk is requesting that those applications' continued hearing dates be corrected from November 3rd, 2015 to November 2nd, 2015. I apologize for that error.
So moved.
I'll second that motion.
okay, moved by Ms. Curtis and seconded by Mr. Crow, and motion carries.
I believe that completes the agenda.
I think we have one more.
Oh, we do.
Item 76. I was just waiting to make sure
Sorry.
you're caught up, Mr. Vlahakis. Okay, item 76, application 14-11311, applicant is 696 Hampshire SPE LLC.
Kenton Schubel, Ryan LLC for the applicant. And the applicant would like to request a withdrawal of this application.
A withdrawal?
Yes.
Okay. So no action required by the board, and thank you, Mr. Schubel.
Thank you.
Okay. And Mr. Vlahakis, I'm not sure if you, did you get that one?
Yes,
Okay.
that's sufficient.
Okay, so we've gone through the whole agenda, and we are left back with Mr. Ashley. So come on back up.
All right, thank you.
Sure. Before we get started, let's just take a second. We're going to get the application out and make sure
Second,
we're
sir. I haven't
in good
passed
shape.
it out to the board yet.
Okay.
It's okay.
And so, just real quickly, we'll start. We already went through an overview of what we're looking at, and this is, I believe, it's Prop 8, the decline in value, everything resolved. So, in terms of burden of proof, and we're dealing with sales tax issue, I believe. My understanding is that would be with the applicant, but looking for clarification there.
Technically, I believe it would be with the applicant.
Okay. Any?
Mr. Chairman, can we also clarify whether or not findings are still requested?
Oh, sure. Mr. Ashley, there's a box on your application check saying that you are requesting findings of fact, which is a record from our attorney.
Correct.
Okay. And we'll just confirm with the clerk that that's been taken care of.
The payment has not been made. It's required before the board makes their decision. So,
Okay.
assuming the applicant pays before the close of the hearing, otherwise findings of fact would not be issued.
Okay, so that's probably something that would need to be done now, right?
Before the conclusion of the hearing.
Okay.
So I can't make them pay until just before the board concludes.
Do you take Visa?
Checker cash.
Okay, thank you. Yes, we were. So it will be cash.
So you have that now, or you just want to?
Whatever you guys wish.
Why don't we just take care of it now? I think that's the normal procedure, right? Otherwise, it'd have to be during the hearing sometime, which might be inconvenient.
Before you take everything under
make our
submission and
decision.
close the hearing is when
Oh, I understand.
they can pull back. And then if they do, they can ask for them. So,
Okay. Well, I think it's too late now, probably. Okay. Gone through the overview. So we'll start with, we'll go through a presentation from the applicant. You can hand out any information you have. The board and the assessor will have time to ask questions, and then we'll go through the same procedure with the assessor's presentation, closing summaries, and then the board will make a decision. So whenever you're ready to start, if you do have any info to pass out, now would be the time.
All right, as I said before, this matter basically had 4 factors to it. The original value of the airplane, the tax, the the original value of the plane.
It's valued at 4.
Right, but the tax, and then, the contention that we had filed late and there was a 10% penalty on that. In dealing with Mr. Goldberg from the Greenberg from the assessor's office, the first matter was resolved, and I believe we stipulated previously that we are now at the $3,050,000, which we agreed to. The assessor's office came back and gave us an email that the penalty was not accurate. We had filed and paid on the original amount on time. That was dropped. And we were down to the matter of the sales tax. In discussing this with the assessor's office, we gave them, and we were told today that the assessor's office had all the documentation that they needed on this. We gave the assessor's office the documentation that this plane was not purchased in California, had gone through an audit in Sacramento, and we were excluded from sales tax on the state level. They explained to us that that did not excuse their ability to still assess the plane on a sales tax matter. We then received additional documentation from the assessor's office in 3 different categories in their records, so to speak, that sales tax may be assessed on personal property, this particular airplane, to, in fact, bring it into fair market value. We went back to the assessor's office and explained to them that this airplane, at the present time, is now assessed at fair market value, which is the $3,050,000 that I believe we have agreed upon, and that the addition of the sales tax would, in fact, take this plane out of fair market value. So in the documentation that we were given by their office, it was clear that they do have the right. I definitely question the contention that there is an obligation. It does say that they have the right to assess that on personal property, again, to bring it into compliance with fair market value. We are at fair market value on the amount that we have agreed upon. This would take it over the fair market value. And more important, this plane, as with most planes, but this one definitely, can be sold any place. It can be sold in California, at which time the assessor's office would get sales tax, or the state would. It can be sold any place in the United States or Europe or any place else. This plane is going to be purchased. If it is sold at some time in the future, it is going to be purchased by somebody at fair market value. Not California fair market value, whatever the plane would be if they bought this same plane in Utah. Now, the value of this plane, we contended, was between $2.8 and $3,050,000. We have stipulated that we will live with the higher amount. We've already paid way more taxes than on that figure. But that figure is fair market value. The addition of the tax is inappropriate because it takes this plane out of fair market value, which is the very justification in the documentation that the assessor's office supplied to us that was the intent to keep everything even. That's where we stand at this time.
Okay, thanks, Mr. Ashley. Do you have any other information, comments before we go to questions?
No, not that are pertinent.
Okay. So
Are we marking the applicant's exhibit as number 1 collectively?
yes, thank you. This packet we'll call applicant's exhibit 1. Mr. Curtis, did you have a question?
With respect to the tax issue specifically, was there anything in your packet addressing the taxes versus other issues?
Well, there was something under Exhibit A where, Exhibit I, I'm sorry, where there was a market perspective that we supplied the assessor's office that shows this plane to be valued at $2,850.
Okay. All right, thank you.
Mm-hmm.
Okay, then we'll go next to questions from the assessor to the applicant. Okay, take your time.
On Exhibit B, it indicates that the purchase price was $3,450,000.
Correct.
So how did we get it down to $3,001,000?
That was over 2 years ago.
So you're saying it was 2 years ago.
And these planes do, in this market, depreciate very rapidly. And again, the spread today, if this plane was bought, would be $2.8 to $3 million.
Is there a picture of the plane in your exhibit?
Yes, there is.
It is.
There's an answer.
Oh.
There you go.
Exhibit E.
E, all right, thank you.
I'm going to, just to make sure everybody's on the same page, show the applicant a page. Is that the page with the photo of the plane?
Correct.
It has a heading of jet effect, and then it has the Embraer Phenom 100 SN, and then a number after that on the top right.
Mr. Meyer, I'm not trying to rush you. I just want to make sure that we're still in the same
Yeah, I'm looking at
status.
some of
Okay.
his exhibit
Take your
here.
time. Go ahead.
I'm looking at Exhibit I. You've got some quotes here from assessor's handbooks. And you have a letter from the state granting you an exemption due to interstate and foreign commerce for the consumer use tax.
Correct.
Now, are you familiar with consumer use tax and sales tax are?
Yes, it was discussed at length with your agent.
Okay. For the board's information, consumer use and sales tax are two different things. Typically, sales tax are applied to something that's purchased within the state of California, where consumer use tax is applied when somebody purchases it outside of the state and brings it into the state, and it's applied by the State Board of Equalization. There are certain exemptions based on flight time and what the plane is used for during that time. If more than half of the flight time in the first 6 months of ownership is outside of the state of California, then the consumer use tax is not applied. And that's what this exemption is for. You agree with that?
Yes, that is correct.
Okay.
We agree.
I really don't think I have any other questions.
Okay. Any questions from the board to the applicant?
So with respect to what the assessor just said, how much time was spent in California within the 6 months, within the first 6 months?
More than 50%.
More than 50%.
More than 50%. And now it is also used out of state more than 50%. It goes-
Now it's being used.
Correct. It was purchased for out-of-state business.
Okay.
We hold sharings all over.
But this plane, we are not debating or contending that the tax that the assessor's office has billed us for is not due them, even though the timing, we 10 more hours on the plane and that wouldn't be applicable. The logs are part of this. So we're not contending that. We are willing, in fact, we have paid the tax. We just do not believe that this tax, on top of the tax that takes the plane out of fair market value, is appropriate in this matter, even from their own documents that they supplied to us. That's the only contention that we have left on the table.
Sure. I understand what you're thinking. I mean, how does this, if I'm going to sell a car, I'm selling it at fair market value. I don't really factor a tax when I transfer the car. With respect, how is it any different if I'm just going to sell my used car?
If I'm following you, I don't believe there is any difference. If a car is purchased in Utah, mm-hmm. and it is brought to Camarillo, and it is licensed for the years that car is driven in California, there is a tax in the way of your licensing fee, because it's registered in California, that is paid based on the value of that car. Not added tax, the value of that car, regardless of where it was purchased, and that, to get your tags, is paid to DMV every year. At the end of 5 years, the owner that may wish to sell that car has two options. He sells it in the state of California and the buyer pays the sales tax and pays his tags, and it's exactly the same. But if that individual would take this same car and go to Las Vegas and sell it, the state of California has nothing to do with it. They were paid each year that it was driven and used on California highways, but it's got nothing to do if it was sold out of California. That is the exact contention that we have here. We understand our obligation to pay the tax, the personal property tax, each year that this plane is in the state. We've already done that on an inflated value that they stipulate was not appropriate at the time it was put. We don't have a problem paying that. We'll pay it every year that that plane is here. But it's got nothing to do with then an additional tax. I understand the assessor's office if we contended that these planes were being sold for, let's say, $2.8 million throughout the world. And we came along and said, yeah, but we got a really good deal when we bought this plane, wherever we bought it, and we bought it for 1.5. They would have the right, again, we see that, stipulate that that is the case. They would have the right to add that tax on to bring that plane in line with other planes of the same type in the state of California. But we're stipulating that on the spread between the 2.8 and the 3,050,000, we say, okay, we'll take the higher assessment. As we've talked about, we'll pay our tax on the 3.50, but don't add another tax that has nothing to do with fair market value on this particular asset.
Okay. Any comment from the assessor?
Yes, I'm looking at the State Board of Equalization's website regarding consumer use tax. It's asking what is the difference between sales tax and use tax. In California, transfers of tangible personal property for a consideration, sales and purchases, are subject to sales tax or use tax unless the law provides an exception. That is, an exemption or exclusion. Although the rates are generally the same, sales tax is imposed on the retailer for the privilege of selling tangible personal property in the state. The retailer may collect reimbursement from their customers if the contract of sales so provides. Although this is usually invoiced as sales tax, it is actually sales tax reimbursement. Whether or not the retailer collects reimbursement, the retailer is liable for the use tax. Further, it says use tax is generally imposed on the purchaser of tangible personal property that is used, consumed, or stored in the state. Sales of vehicles, vessels, and aircraft by licensed dealers are usually subject to sales tax, for which the sales tax reimbursement is collected at the time of purchase. Use tax applies to the cost of vehicles, vessels, and aircraft purchased from non-dealers, for example, private parties, or from outside California use in the state. Use tax also applies to most leases of tangible personal property. Private party sales or broker transactions are normally subject to use tax. So I'd like to emphasize private party sales. If the first use of the property occurs in California, use tax may apply even if the purchaser is not a resident of the state. The sales and use tax are mutually exclusive, which means that either sales tax or use tax applies to a single transaction, but not both. So this is basically saying that, yeah, they are subject to sales tax. Even automobiles are subject to sales tax. That's why you have to fill out your pink slip when you sell your vehicle and send it to the DMV, or notification to the DMV within 30 days.
Okay. Any other questions from the board?
This unit was bought in Oregon?
Correct.
Mr. Chairman, I have a question. You referenced that in materials sent by the assessor's office, they had referenced that it's appropriate to factor in sales tax, but not if adding the sales tax caused the total plane amount to exceed fair market value. Can you point me to where in your Exhibit 1 packet I could find the references that you were mentioning?
Exhibit 1 being...
That would be the packet that was distributed to the board.
Okay. That was not included. That was an email. Say it again, though, Marina. I'm sorry. I will have to prepare the legal findings of the board, and so it's very important that I understand the legal basis of both sides' argument. And I understood the applicant to be making the argument that you don't factor in sales tax if when you add sales tax to the value of the plane, you then exceed fair market value.
And I wanted to know what legal proposition, regulatory or statutory site you're relying on.
And you do not have that in your packet. It was in an email. I'm Tiffany Scatalia, by the way, Brendan. It is in an email where we cite, and I can make copies of that. You do not have that. It's an email where we cite AH 577, Chapter 3, page 12, and also AH 504, Chapter 4. And I'd also like to say that fair market value should not include sales tax. When you go to sell your car at $4,000, you're not thinking, you don't add sales tax, you're selling your car for $4,000. That would be the fair market value. You cannot include the sales tax in going out of, I mean,
if I may just add to that. The assessor's office has the ability to add this tax, and they can call it whatever they wanted, to the value of the airplane, if it is done in a manner to bring the plane to fair market value. Mr. Meyer read a very lengthy item here for the board's consideration. And I agree with everything I just heard. But this plane was not subject when it was purchased. It wasn't purchased in California. There had been an audit by Sacramento. That audit was attended, discussed, and the state determined that there was not a tax due on that plane. Now, Mr. Meyer was saying it's one or the other, and we're not debating that. That was 2 years ago. The plane now is at Camarillo. We have a personal property tax due on that plane because it's in California. We're not debating that. They appraised the plane for $3.95 million, which was more than the plane would have been brand new. And then they came back and said, okay, that's not right. And by the way, there's another amount due because you didn't file this on time. After a week or so, oh, yeah, we made a mistake. You don't owe that. Then they came back with the stipulation that the plane is worth $3.50, which we felt was at the high side of what it is valued. Worldwide, not California, not here, not any place that this plane would be purchased. That's what a buyer would expect to pay on the high side for this plane. We agree with that. What they're now saying is, oh, we're going to add, which has nothing to do with the fact that the plane was exempt in the beginning. We are now going to add another $230,000 value to this airplane to bring it up to market value. What was not read today was what Tiffany just mentioned, is that while the documents that we were given by the assessor's office to show us that they had the legal right to add this on, it's not being debated. I know they have the legal right to add it on, but it does not say in any of the documentation that we were provided that it is a requirement. It is a tool, and it goes on to the third one that we mentioned here. It is a tool that the assessor's office may use to bring a personal asset to market value. They've already done that. We have agreed to the value of this plane. There is no reason, there's no justification whatsoever now to go back and add another $230,000 to the value.
All right, so just so I'm clear, you're objecting to the increase in the $230,000, or you're objecting to paying the purchase tax?
Well, the purchase tax, there was no purchase. We're not, we are not We are not objecting to paying the use tax or whatever
Right.
label. We're paying that. We've already paid way more than that.
Okay.
At $3,050,000. Fine, we'll pay it. We'll pay it next year if it's here.
What are you objecting to?
We're objecting to the additional $230,000 that the assessor's office is attempting to add on to the value of this airplane after with the fact that we have already agreed that the value of this plane is $3,050,000. That would take it to $3,004,000 or $3,350,000, which is way out of line for this plane any place in the world.
So it would raise it to $3.28, right? Okay.
8 or 9, yes.
3,278.
50.
500.
So that's what you're objecting to?
Yes.
Okay.
That increment added to what we have already
Gotcha.
stipulated.
All right. Did the assessor give their presentation yet?
Not yet.
Okay.
We're still asking questions.
Oh, okay.
Go ahead.
I'm good. I'm done.
Any other
Thank
questions?
you.
Okay, let's go to the assessor's presentation. Thank you.
Kent Meyer, Ventura County Assessor's Office. If you could turn to page 3 of Exhibit A. Under application for change assessment, I have a grid here with all the valuations on here. The original value on the roll was $3,995,420, with a 10% penalty assessment also involved with this. The applicant's opinion value was $3,050,000. And the assessor is recommending $3,278,500 with no penalty assessment. What happened as far as the penalty assessment is concerned, there was a late filing assessment. Typically, airplanes are required to file their aircraft property statement no later than May 7th of each year. Their property statement was handled independently, and we had a specific date of May 25th as far as the date that it had to be handed in. And they did hand it in prior to that, so we want that penalty removed. The difference between the applicant's opinion of value and ours is the difference between market value versus assessment value. We do not disagree with the applicant that they would probably or try to sell the plane for $3,050,000 and that they could probably get that price. The difference is, for assessment purposes, we are required to add sales tax as an adjustment to that value. This is supported by Property Tax Rule 10. And that's printed in its entirety, beginning on page 10, Section B. About midway down, it says, full economic costs includes costs typically incurred in bringing the property to a finished date, including labor and materials, freight or shipping costs, installation costs, sales or use taxes, and additions for marketed, supported entrepreneurial services. The assessor is required to follow these rules, so this is the legal obligation on the assessor's part. Also, I'd like to point out that property tax, sales tax, added to the assessed value or the fair market value was upheld in a California appeals court in 1977 between Xerox Corporation and Orange County, and that is also referenced here on page 4. I'm sorry, page 5. Bottom page 4, beginning of page 5. The assessor's handbooks, 577 deals with general aircraft, specifically regarding the sales comparison method. And the sales comparison method, Chapter 3, page 13, delves into the comparative sales approach where sales tax is not included in the value shown in any of the value guides. The general rule in determining market value is that where the price is the basis of value, sales, use tax, freight, and installation costs are elements of that value and should be included in the estimate of market value. So based on all of this, the assessor feels that the stipulation of $3.278 million is the value that the board should uphold.
Any other info from the assessor, Mr. Meyer?
No other info.
Okay. And so now we'll go to questions from the applicant to the assessor based on their presentation. And just as a reminder, you'll have a chance for a closing summary to summarize your position. So this is just time for questions.
Oh, I'm sorry. Mr. Meyer, thank you for this. In looking at it, going back to page 10, under paragraph B, tangible personal property held by a consumer shall be valued at the amount of cash or its equivalent for which the property would transfer to a consumer of like property at the same rate trade level if exposed for sale on the open market. I believe this is very clear that the assessor has the right to include certain things, being transportation, taxes, maintenance, etc. But the intent of the assessor's office, whether it's personal property or real property.
I'm going to interrupt you just for 1 second. So this is just time right now to ask questions of the assessor's presentation. You'll have another time for a final summary. So if you do have questions, based on what they presented, this would be a good time.
All right, Mr. Meyer, is it your contention that this plane on the open market, whether it was sold in California or any place else, is higher than the $3,050,000 that we discussed earlier today?
I believe that it could sell for $3,050,000, but it would also apply sales tax to that, and that, for assessment purposes, must be added to the full economic value.
All right.
Or the fair market value.
If I understand what I think I just heard, Mr. Smith from Nevada attempts to purchase this airplane. In checking the value of this airplane, he determines that this airplane, its fair market value is $3,050,000. He makes an offer to purchase the plane for that amount. And he's buying it from me, and the plane is in Camarillo. Now, he would be buying that plane for $3,050,000. But at the same time that he is purchasing that plane from me, he would owe sales tax to the state of California, whatever the rate for Ventura County, at that rate, just as if he was buying a car. And that is the total price he would pay. My plus the sales tax would be the total amount that he would pay on this plane. Is that correct?
Correct.
All right. If this same individual was buying this same make, model plane in Idaho, he would be paying $3,050,000, and he would be paying a sales tax if there is one, I don't know whether there is or not in Idaho, of whatever that Idaho sales tax amount would be if the plane was in Idaho and that's where he was buying it. Is that correct?
Not knowing what the sales tax laws are in Idaho, it sounds reasonable.
All right. He would not be paying, if that's accurate in Idaho, and I understand you don't know, I don't either, he would be paying the $3,050,000, he would be paying the sales tax in Idaho, but now for the amount of time that that plane is sitting at Camarillo, I am being assessed by your office an additional $240,000 approximate dollars in evaluation on that plane, even though I believe we have just agreed that wherever that plane sells, the base price is $3,050,000. What that individual would pay to any governmental agency where that plane was purchased is between that individual as the purchaser and the state that it's being purchased in. It doesn't change the value of that plane, because if this individual found this plane in a state in the union that doesn't have sales tax, and he buys this plane at $3,050,000, he is getting the same exact piece of property at $3,050,000 that you're contending, your office is contending, is worth $3,050,000 plus another $240,000 on top of it. It is a tax on a hypothetical sale that hasn't occurred and may not occur. And it takes the plane out of fair market value, in my opinion, and puts it into a whole nother category that isn't fair market value. Is it the assessor's responsibility to assess taxes, real, personal, whatever, on fair market value as per your handout that represents what that piece of property or asset would sell for on the open market? Isn't that what your handout states is fair market value?
The assessor is required to appraise all property at fair market value and full economic value as of lien date. Now, personal property is not subject to Prop 13 at all. It's a completely different entity than real property. The board members are more typically familiar with real property than they are personal property. So for lien date purposes, we have to bring it to full economic value. And we would look at the total value or price that a consumer would pay for the property to bring it to full economic value. That would mean the sales price plus sales tax. As stated in Property Tax Rule 10, Section B, when you go down to full economic cost, which I've highlighted there.
How is it that a piece of personal property that can be identical, I believe there have been around 320 planes manufactured of this model and make, that have sold all over the place, way less than 10% in the state of California. Since this is an asset that is being kept here, therefore I, as the owner, have an obligation to pay for it being kept here. But I can sell this airplane, can I not, any place in the world, and there's no obligation for me to sell it in California. Is that correct?
I don't believe there's an obligation for you to sell it in California, no.
Okay. So if I sell this particular airplane any place outside of California, and let's assume that there are 50 other planes of this make and model in the rest of the quote world, isn't fair value of this plane has to be measured consistently with what this plane would in fact sell for anyplace else, since I'm not obligated to sell in California.
Absolutely not. We are here basically because of California state law, not world laws or some other state law. We're here to determine what the fair value of the property is pursuant to California state law.
Okay, I think we have a clear understanding of the difference in opinion and the applicant's view of the issue. If you do have any other questions on...
No, not for the assessor's office.
Okay, great. Let's go to any questions from the board to the assessor.
To the assessor, so this valuation, the tax on the value, that's pretty typical for airplanes, correct?
That's typical for all personal property. So aircraft also.
At what price point does that start off at? It wouldn't be like a car.
There's no price point on it. And the assessor does not handle vehicles, automobiles. We handle aircraft, boats, and all personal property at businesses.
Okay, so it would, even if it was an airplane, maybe that didn't work or something, or?
There is an exemption if it's in the county for the purpose of repairs and such. But if there's a fair market value on the plane, we are going to assess it, and we will add sales tax to it. Sure. Unless there's some exemption for that sales tax. For instance, air carriers are exempt from the sales tax rule.
Okay.
Mr. Crow, any questions? Okay, I don't have any others right now either. So we'll go next to closing summaries. We'll start with the assessor, we'll finish with the applicant, and then we'll deliberate and make a decision. So go ahead.
The Ventura County Assessor's Office would like the board to sustain our recommended value of $3,278,000. We basically applied the sales tax to this property because we are required to under Property Tax Rule 10. Assessor's handbooks support it, and court cases support it, specifically Xerox versus Orange County. And that's it for a closing statement.
Okay, thank you, Mr. Meyer, Mr. Horn. And closing summary from the applicant.
I would request that the board instruct the assessor's office to use the stipulated assessment value that we discussed today of the $3,050,000. I believe that, again, in the documentation, page 10, it is very clear from their own documents that the assessed value is fair market value. It doesn't say California. It doesn't say United States. It doesn't say South America. It says fair market value. Mr. Meyer brought up a situation with, I think it was Xerox or one of the companies. I think there's much to be said between an asset that is used in California in a business situation solely in California. If I own a company and I've paid Xerox or whoever for a piece of equipment that I'm going to use in my California business here in California until that piece of equipment dies, I believe he's very logical. And I think that's what the court looked at. This is not that. This is a piece of property that is intended for interstate commerce. It was determined by California Board of Equalization. It is being used for that purpose. We are close to the 50% where we wouldn't even be having this, but it's not there, so we are having it, and we say fine. This is a different situation. Again, it is the assessor's obligation, and by the time you read through everything that we have been given, to assess on fair market value. They can add if it's below that, but they can't add on top of top fair market value and then another tax that may never come about because this plane may not be sold in California now or ever. They can add the tax that it collects for it to sit over at Camarillo. We're not debating that. We're debating this tax on a hypothetical tax on top of it, which puts it out of fair market value. Would really appreciate the board's consideration of this. Thank you.
Okay, thank you. We'll close the hearing, the public hearing for deliberations, and believe the board will take a little bit of time to deliberate in closed session. We'll research some of the laws related to the case. We'll come back out and make an announcement of the decision. Probably not too long. However, the applicant, you can stay and wait, or if you want to go, we can have the clerk would have a minute order and information on the decision if you want to check back in later today. So,
thank you.
So we'll be in recess now for deliberation. If I can figure out what item that was. Okay, we're back on the record. It's 12:18, and the board was in closed session for deliberations for item
Yeah.
Yes,
54,
thank you.
54.
Thank you. Item 54, Ashley Construction, Inc. And the board needs more time to continue its deliberations for additional research, and so that will be left open and be continued. And we'll next go to items item 78 on the agenda, stipulations. And I believe we all received those ahead of time. Any questions or comments on stipulations? And if not, we'll look for a motion to approve items 79 through 109, which are the stipulations.
So moved.
I will second that motion.
Okay, moved by Mr. Curtis, seconded by Mr. Crow, and motion carries. And we'll go next to public comment. Okay, and board comments? Great, so we are adjourned at 12:19.